Money laundering, contrary to Section 3 as read to Section 16 of the Proceeds of Crime and Anti-Money Laundering Act 15 September 2015 within the Republic of Kenya, being the Governor of Murang'a County, Directors of Top Image Consultants and Value View Limited respectively entered into an arrangement to transfer of Kenya shillings 600,000 towards the payment for the boreholes blasting in the property number LR number Mwiga Tungare Block 2 Tungare 2 on accounts of monies paid unlawfully to the county government by the county government of Murang'a to Top Image Media Consultant Limited, whose effect was to disguise the source of the said money, while you jointly and severally ought to reasonably have known that the money, the same, formed part of the proceeds of crime. Your response?
Not guilty, don't own such a personal blood.
Not guilty, Your Honor. Not
Media consultant, whose effect was to disguise the source of the said money, while you jointly and severally ought to reasonably to have known that the same formed part of the proceeds of crime. Your response?
Not guilty, not part of Top Image.
Not guilty, Your Honor.
Solemn guilty, Your Honor.
For accused persons with their respective counsel of the charges. Senior counsel
under Constitution 2010, and therefore our need to adhere to the principle of fidelity to our Constitution. Therefore, it's the right of every Kenyan, Your Honor, who is brought before Court of Justice, they plead not guilty, the right to bail is a constitutional right. Your Honor, I wanted to invite you to take judicial notice of the following stark reality. Namely, and that's what I mean by fidelity, even to our multi-party democracy. I talk of judicial notice, Your Honor, because the process of national dialogue, which took place at Bomas, is undergoing the necessary parliamentary procedures, and the matter of fidelity to a multi-party democracy was heavily canvassed during those consultations. Your Honor, the first accused is brought before you 10 years after the alleged commission of the offense of conspiracy, for example. Therefore, we invite you to take judicial notice of the stark possibility of political persecution and aggression against the principles of multi-party democracy. As a member, as the leader of Osawa political party, he is also a member of my coalition, Azimio la Umoja, One Kenya.
The party, you can assist me with the name of the party?
Yes, indeed. Usawa political party, which is a member of Azimio la Umoja, One Kenya coalition. And aggression against any member of any coalition, call it even Kenya Kwanza, is seen to be aggression against constitutionally provided for arrangement of our democracy. Members of that coalition are in court today. The deputy leader of ODM, the Honorable Wycliffe Paranya, the Honorable Eugene Wamalwa, the leader of DAP Kenya, and of course our own members, some of whom are counsel and properly before this court. Therefore, allow me, Your Honor, to invite Counsel Tengwa Njiru to prosecute along with Counsel Wilfred Nyamu, to prosecute the matter of application for bail. Thank you, Your Honor.
The accused person. That is at paragraph B of the said section. The court is enjoined to evaluate the character, the antecedent, the associations, and the community ties of the accused persons. The first accused person, Your Honor, has gone on record that is the most immediate governor of Murang'a County, having served a full constitutional term of 10 years. It tells you, Your Honor, that our client has a serious societal ties with the community, subsequent to which a successful election ensues. It has further gone on record, Your Honor, that besides him being the immediate governor, he's also a leader of a political party, registered pursuant to Article 90 of the Constitution. It tells you again, Your Honor, that he has a serious societal association, societal ties, because he's leading the members of his party. Additionally, Your Honor, it has gone on record that besides him being a member of a political party, he has also his associates. That is the law. And his associates are evidenced before this court. I have had senior counsel mention Honorable Wycliffe Paranya. I have had senior counsel mention Honorable Eugene Wamalwa. Very fundamental societal players, one of them being the immediate minister, was Cabinet Secretary for Defense, and Honorable Wycliffe Paranya being the immediate governor of Kakamega County. That is the association the court must look into, among others. And whether of the accused person to attend for his trial. That is to mean, for example, if Honorable Wycliffe Paranya was to stand surety for the accused person, would the accused person generally abscond for his trial, granted the strong association look at in the question of the association? Thirdly, Your Honor, the court is invited to look at the question of the strength of evidence at paragraph D. The strength of the evidence of his having committed the offense. So even at this juncture, so as to protect the rights of an accused person to liberty, vis-a-vis his presumption of innocence, the court is being invited to look at the evidence. Previously, Your Honor, that was not the position. But this position has been constitutionalized pursuant to Section 7 of the 6th schedule, which provides that whenever the court is applying the law, the previous legislations must be brought into conformity with the Constitution with the necessary modifications, adaptations, and alterations so that they can bring to full realization of the rights of an accused person. That is to mean, Your Honor, if the accused person, in pleading to the charges, says, I do not own that land, I do not own that property, can that just go undiscounted? That is evidence. The court is being invited. And embarrassing so, Your Honor, this juncture. Therefore, the law presumes that even at the particular time of taking plea, the prosecution should avail evidence so that the court may have the opportunity to evaluate the imports of Section 123, Paragraph D. In this case, Your Honor, the benefit goes to the accused person. The law is not saying, look at the amount in question, because the amount in question is evidential. At this time round, we do not know how much money, if at all, was lost. These are mere allegations. And therefore the court is being invited to exercise reasonableness, and I wish to rely on the case of Edel Sum, S-U-M, versus Republic. Edel Sum versus Republic, 2022, EKLR. Nyakundi J had this to say. That in reviewing the board and
So, with the submissions,
I believe it for good order. I can also make submission, then the state responds.
Is there which party are you representing?
My Lord, I am representing the fourth. Yes, Your Honor, as they say, a defense counsel is supposed to be emotionally